Okay, well, I think we'll go ahead and get started. For those of you I haven't met, I'm Danny Quissel. I'm the Executive Vice President for the Water Users Association, and I work with the Water Resource Districts Association, particularly on legislative stuff. And we're really excited to be able to offer some training opportunities for Water Resource District staff, including secretaries. And really excited to have Sean Fredricks with us today to talk a little bit about open meetings, open records, all the things we need to know on that end. So just a couple of housekeeping things before I turn it over to Sean. We are recording this and it will be available after the webinar. So if you missed something, if you want to go back and watch it, if you want to share this with board members, it'll be available after the training is over. And I would just ask if everybody could stay on mute. And then if there are questions, if you can just raise your hand and we'll call on those as there's a break in the conversation. And with that, I will turn it over to Sean.
Thanks, Danny. Am I able to share? Let's see. Are you seeing this?
You should be able to share now.
Okay, let me try again here. Okay. Everybody seeing that?
Yep, there it is.
All right, cool. Thanks, Danny. All right, so this was originally scheduled for both open meetings and open records issues, but as is my habit, as I started getting this put together, I ended up having way too many slides for both. So I sort of limited it to meetings. I hope that's all right. You know, open meetings issues arise on a daily basis and you have to make judgment calls in a snap. So I thought, tell you what, let's hit those issues first. Open records, you know, if somebody has a question about open records issues, I would advise you to touch base with your attorney. And in terms of responding to most of them are pretty easy, right? Pretty basic, innocuous requests. Can I get this or that? And so, but if you have any questions about responding to open records requests, touch base with your attorney. And there are some requirements in terms of how you respond to those things. So, but I wanted to hit open meetings issues today primarily. Like I say, these issues come up almost on a daily basis, really, in my practice. And for some of you, if you have monthly meetings or whatever, you know, questions come up during those meetings, questions come up in advance of meetings. And so a lot of questions and issues to address. And so I thought I'd just take us through some of those. Please ask questions as we go. Danny, if I'm not seeing somebody, just let me know. And let's talk through questions as we go. So every meeting we'll talk about what a meeting is. Every meeting is important because it requires preparation of an agenda, filing, posting, circulating that agenda, and preparing minutes. And we'll talk about all three of those pieces as we go along here. But that sounds pretty basic, right? But a lot of issues and questions arise out of all of those requirements. You know, when you check the Attorney General's, I don't know how often any of you check the Attorney General's website, but they issue all sorts of open meeting issues and opinions. And that's definitely the most common AG opinion that you see is open meeting issues. And so those are quite common. And you know, most of these issues are pretty minor, right? Maybe that you didn't post the agenda in the right place, or you didn't do it in a timely manner, or you didn't circulate it to everybody who asked for one, or something like that. And like I say, a lot of these are pretty innocuous, but some of them are a little more significant. And also, you know, what are we talking about here, really? Okay, if you violate the open meetings requirements, what's the penalty? All right. So, I mean, technically by statute, there are a few different types of penalties. There can be an Attorney General opinion. And if you violated the open meeting requirement in some capacity, the Attorney General will issue an opinion if somebody requests it and direct you to remedy your violation and whatever that looks like. Maybe Maybe you didn't keep adequate minutes or something like that. And the Attorney General's office will direct you to comply. And I think if I remember right, you have 7 days, et cetera. So that's one potential remedy. One also could be get sued, civilly. Let's say you take action at an illegal meeting. You didn't notice the meeting properly, and we'll get into how what a meeting is, a quorum making a decision, and maybe the decision you make is challenged, and you might get sued, and the decision you made could be overturned. There are damages, statutory damages a person is entitled to. So that can be a serious issue. Also, I haven't seen this in my years of practice, but if somebody knowingly violates open meeting requirements, that's a Class A misdemeanor. So you could be charged criminally if you are a serial violator. I think there's probably a situation where that would arise, or if you're purposely making decisions behind closed doors and you get caught and it's something very serious and it's very clear that you knew you were violating, who knows? Maybe the state's attorney would commence an action, or maybe the Attorney General's office. I don't even know, because I haven't seen it, but I think if something is egregious enough, that's a possibility. Okay, so those are the statutory remedies, but really what we're talking about is, erosion of public trust, right? And many of you have situations in your respective counties where maybe you have opponents, okay? And I work for a lot of different water resource districts. Every single one of them has folks within their jurisdictional boundaries who, for whatever reason, maybe it goes back generations in their family, or maybe they feel like they were wrong during some project. But just about every water resource district has, your villains, right? They'll call us the villains, we call them the villains. But there are people out there, right? And they're watching you, and for whatever reason, and right or wrong, but somebody out there is watching, and they want to bust you doing something wrong, and they want to be able to point to Attorney General opinion or something like that and say, "See, I told you." They're blatantly and brazenly violating open meetings laws and requirements, and they're meeting behind closed doors. And it's just, a lot of folks will try to make a lot out of nothing, but they're going to try to erode public trust, right? And so that's what you're trying to avoid. Obviously, you want to comply with the law, but you also want to demonstrate that, look, we're doing things right. And again, you see violations all the time. A lot of them are not intentional, and some of them are very minor, but you want to do your best, because you don't want somebody to be able to argue that you're out there brazenly violating open meetings laws. So we'll talk about these 3 requirements and what they mean. Like I say, they seem pretty basic, but there are all sorts of open meeting violations regarding each of these elements. And by the way, if anybody at the end of all of this, if you want a copy of this PowerPoint, feel free to shoot me a note. I'll send it to you. I've got some AG opinions posted in here and some statutes. So I've got some statutory language. And so some of this can get a bit, can seem like it's a bit much, but so a meeting is a formal or an informal gathering, whether in person or through electronic means, and we'll get to that in more detail, that includes a quorum, or less than a quorum, basically, if we'll get into committees and things like that. Something less than a quorum if that group that constitutes less than a quorum is basically conducting public business and you're attempting to violate open meetings laws. And what does that mean? So again, we'll get into committees to some degree, but a lot of times now with the advent of electronic communication, when they first passed the statutes that addressed electronic communications, they were talking about emails and things like that. Then they started thinking about text, and then they started thinking about instant messaging, and then we had Teams and things like that. And so they just made it a little more generic and talked about electronic means. But there are other ways of avoiding open meetings requirements and quorum requirements. and doing so deliberately. So for example, if you have a 5-member board, maybe two folks meet on site, and then the next day 2 other folks meet on site, and the next day one of those board members meets with one of the others, etc. So there are different ways, right? Creative ways to violate quorum requirements. And that's why this statute is worded the way it is. And basically what they're saying is, look, if you have a quorum or something that basically equates to a quorum, then you've got to follow the open meetings requirement. That's a meeting. Okay. And again, we'll talk more about what a meeting is. But so for a quorum, obviously, it's more than half of your membership. So most of you probably have 5-member boards, and some of you I know have large boards, right? And I think I saw Mary was on and some others. So some of you have very large boards, right? So we're talking more than half of your board. In Cass County, for example, a lot of the water resource districts only have 3 members. That creates some real difficulty when you're talking about a quorum, because you can't just call up one of your board members, your fellow board members, and talk about something. That right there is a meeting violation. And we see it with townships all the time. Townships, and this is not at all a commentary on townships, but they have difficulty complying with these things because township board members are out there. They might run into one of their fellow board members driving out on one of their township roads, maybe inspecting damage from a recent flood or something like that. It happens all the time. Township boards have 3 members and they run into each other, and then they talk, and then inevitably that leads to discussion of public business. Well, that's a violation because you got a quorum, right? 3-member board, 2 members happen to meet out on a township road. That's a violation. Well, if your water resource district only has 3 members, same thing. And so you can't call each other, or you can't talk about anything, or maybe you run into each other at the grocery store. You can't stop and chat about, well, did you see what happened on Drain 99? You just can't do it. It's a violation. And so obviously, if you have 5 members or more, it makes life a little easier. But again, we'll get into the committee stuff in a little more detail. But that those quorum situations create difficulties, obviously. So this is a situation that happens all the time. Attendance at another meeting. And maybe some of you have done this, right? Maybe you've attended a county commission meeting or something like that. Your county commission has control over your budget, right? And so they have their budget hearing, and maybe you decide, well, I'm just going to go to the county commission budget hearing and listen in, because they have our budget on there, and they're going to discuss our general mill levies. So I'm going to show up. Maybe you show up. Maybe it's the house is packed. Maybe the commission is discussing whatever. Maybe they're going to build a new courthouse, or so maybe there's a large turnout in a large conference room. You show up, unbeknownst to you, 2 of your other fellow board members are in the audience. One might be on the other side of the room. One's in the back having coffee. You don't realize they're there, but let's say one of those aforementioned opponents of yours happens to notice that you're there, and happens to notice that the other 2 board members are there, and submits an AG opinion request. Okay, so what does this mean? You're in the audience. You're not asking any questions. You don't ask any questions. All you do is you sip some coffee and you listen. And you hear the commission talk about your budget request. You don't talk to any of your fellow board members. You don't raise your hand. You don't ask any questions of the commission. Are you conducting business? Is that an open meeting violation? The Attorney General has concluded on several occasions that yes, in fact, that is a violation, because you have more than a quorum at a meeting. And folks have always suggested to me that I get pushback on this all the time. People will say, well, we didn't pass any motions. In fact, we didn't even talk. So that's not a meeting. And I understand that rationale. I get it. But I always have to explain, look, the Attorney General has concluded otherwise many, many, many times over decades, right? So if you show up and you're at a meeting, even if you don't participate, even if you don't talk to your other board members, even if you don't know that they're there, The fact that you have a quorum there is a meeting, creates a meeting in quotes, right? It's a meeting. Why is that? Because it pertains to public business, to your public business, because they're going to discuss your budget. And so it pertains to your business. And so even if you don't discuss it with your fellow board members, you don't pass any motions, and even if you don't know they're there, you're talking about public business. And so water resource district business, whatever board you have. And so that is a meeting because it pertains to your public business. And so, it's always helpful if you know that there's, for example, if you know the county commission again is going to be discussing your budget, or let's say they're discussing one of your board members retired and they're going to discuss the possibility of appointing a new member, and it's going to be happening at their meeting the next Tuesday. Maybe at your board meeting you say, well, listen, it sounds like the commission is going to be appointing a new member to fill Tom's spot. Is anybody planning on going? Well, I'm thinking about it. Blah, blah, blah. Maybe it's a good idea to make sure that you're not going to have a quorum show up, because if you are, then you should notice it as a meeting. If there's even the remote possibility that a quorum could show up, I would err on the side of caution and schedule it as a meeting, create an agenda and schedule it as a meeting. That way, like I say, your opponents aren't going to come after you and you're not going to get dinged for an open meeting violation. I put this example. So that's a very common situation where you show up at county commission meetings. It applies to all sorts of other public entities. There are situations, this comes up all the time, testifying in front of the legislature. So we have, maybe you'll get an alert from Danny or Jack or something saying, hey, the legislature is going to be hearing HB 5000, right? And this pertains to, water resource district drainage complaints. We'd like it if you showed up to testify in favor of this bill. Okay, so you get that alert and you decide you're gonna show up out there, and again, unbeknownst to you, a couple of your fellow board members show up. Well, there you are. You got a quorum at a public hearing. Or maybe you all decide to show up together and you say, look, let's all ride out together. Let's all show up and testify, or at least sign in favor of the bill. That's a quorum. And so I've had this situation arise many times over the last several sessions where there are board members that I know there's going to be a quorum showing up. So I'll put together an agenda, or I'll work with the secretary to put together an agenda saying, the North Dakota legislature, Corn County Water Resource District special meeting agenda. And then I list the hearing date and time and location, the hearing room, if we know it, and indicate that the legislature is going to be, the one agenda item is HB 5000. Legislature is going to be discussing HB 5000. A quorum of the Corn County Water Resource District may be in attendance, or something like that. That way you're in the clear, okay? And we'll talk about where you got to post those. But then you get an agenda put together, and nobody can claim that you violated open meeting violation, or that you violated open meetings by showing up at the legislature. That's another common occurrence, right? If your board is active in legislative matters, hopefully you are, that's pretty common violation.
Sean, I have a question then. So would this be the same like when they do like the winter conference meeting and then the summer conference meeting? We should actually, if we know a quorum of our board members are going to be attending that, we should actually set up an agenda and post it and all that then too. Would that be the same then?
That's a great question. There is actually an exemption for those types of meetings. I got it here just a couple slides later, but that is a very good question. There are a few exemptions, and the summer meeting and the convention in December, those qualify under those exemptions. And there are a couple others. I'll get to that in just a minute. That's a great question. I'm glad you asked it.
Thank you.
And yeah, it leads to other questions, which we'll discuss when I get to the exemptions. But yeah, great question. All right. So series of smaller gatherings that collectively involve a quorum. So under the statute, this particular statute specifically calls out public entities and saying that, look, if you have less than a quorum attending a meeting, but collectively, ultimately a quorum meets, whatever that means, and it could be electronically, or again, it could be on different days, etc. That is a meeting. Okay, so what exactly does that mean? Well, we see all sorts of AG opinions on this. So let's say an example I have there is a water resource district member calls the other members one at a time. Okay, and each of those calls is less than a quorum. But if you call, if Tom Farmer, one of your board members, calls Ed and says, "Hey Ed, it looks like there's an issue out on Drain 99. Here's what happened." And the farmer called me and I talked to him and here's what happened. Okay, yeah, thanks for letting me know. The next day, Ed calls, Jim, says, "Jim, FYI, I heard yesterday about Drain 99. Sounds like there's an issue out there." "Oh, okay. All right. What's happening?" "Well, all right. You've probably already violated open meetings requirements." Who's going to know about that? I don't know. But maybe you in the process of discussing the matter at your next meeting, maybe somebody in an offhand comment says, "Yeah, well, I talked to Jim." "Oh, yeah, that's right. And I talked to Ed." Okay. And somebody who's sitting in the meeting room realizes, okay, they're all talking about this, and or when did you meet? When did you talk about this? "Well, we didn't have a quorum." And, "Well, how did this happen?" And then maybe everybody gets tight-lipped and the attorney general calls me and asks me to investigate, and I have to call around. "Oh, it sounds like they all talk to each other. It wasn't ever a quorum, but they all talk to each other." Okay, well, there you go. And that's how this happens, is the attorney general will conduct their investigation, and first thing they'll do is call your attorney and ask you to let them know what you know about it, any documents you have. And, if we have to investigate and we find out that, yep, sounds like, three of the 5 board members talked about it. It wasn't all on the same call, but they all talked about it. If you're deliberately trying to avoid open meeting requirements by doing that, then you could get dinged. That could be a violation, right? Another common occurrence is a site inspection. So let's say you have, and there's AG opinion on this, let's say you have a 5-member board, you have a drainage complaint, 2 of you go out and look at it, 2 of the board members go out to look at it, and the next day 2 of the other members go out to look at it, and then they talk. Then let's say Tom and Ed go out on Monday, Jim and Chris go out on Tuesday, and then Tom and Chris talk to each other on Wednesday. All right, 4 of you have conducted a site visit, and you've ended up talking about it. Those types of situations. And so, let me step back for a second. Why is it important that secretaries know this? It's important because that somebody's going to want to conduct a site visit, right? And so it's important for you to ask, "Hey, we got this drainage complaint came in," and you send it out to everybody. Let's say, "Hey, we got this drainage complaint. Let me know if anybody," call your chairman and say, "Let me know if anybody's going to be conducting site visits. Should I notice it as a meeting?" That's why it's important, right? So anyway, but this happens all the time. We get these site inspections, people conduct those, or same thing about the county commission meeting. "Hey, it sounds like the city commission is meeting and they're going to talk about our drain that runs right outside of town. Maybe you're going to have a couple members show up to the city commission meeting. Maybe you just want to notice it just to be safe." You just have to be aware of those situations as a secretary, because you have to understand that you don't just have an obligation to notice your regular monthly meeting, right? You got to recognize that there are other meetings that could occur, and you have to be aware of them. And sometimes it helps for you to remind your board members, "Hey, don't conduct a site visit without telling me," or don't, if one of your board members tells you, "Yeah, I called Jim and then I called Tom," and you might want to remind them, "Look, that's dangerous." I'm happy if I work for a lot of you. don't work for all of you. I'm happy to be the bad guy and tell folks, look, you can't do that. That's an open meeting violation. But sometimes you have to stand up and say, you can't do that, and so you got to wave your hand and say, hey, just remember, we have open meetings requirements. So this last section D here just kind of says, again, you don't have to have the intention of violating open meetings requirements. You just have to have a quorum that ends up violating open meetings. And so when does this happen the most? I've got some examples: emails and texts. That's when this really becomes an issue. And, a lot of you have heard and seen Attorney General opinions about the Board of Higher Education. There were all sorts of issues years ago. And, it turned out there were a lot of emails that they were sharing with each other, all of them in one single email, or a series of emails, maybe exchanged between a couple of them, then forwarded to the others, and then, or maybe one member emails two, and then that one of those members emails three more. Those become real situations. And texting obviously creates some difficulties. If you're doing a group text with a quorum of your board, obviously that's a violation. But if you're texting one of your other board members and that board member is texting another one, it just creates all sorts of issues. And so we'll talk about that a little bit more. But here, it is on the bottom of this page. This example down here, the mayor texted all the other, in this particular situation, a 2019 opinion, the mayor texted all the members of the city commission to talk about an issue. Very blatant, clear violation, right? It's the mayor texting the full commission about public business. That's a very clear violation. This 2017 one, there were some emails exchanged. I think if I remember right, it may have started out, hey, at the next meeting, we should have this on the agenda. To me, that's dangerous. You shouldn't even be having those emails. I think the Attorney General has concluded that, look, if there's a quorum of you on an email saying, let's include item A, on the agenda, the next agenda, that's probably okay. I advise board members, do not email each other, do not text each other, especially a quorum, because that's a clear violation. Even if you're just saying, what time can everybody meet next Wednesday for a special meeting? That's dangerous to me, because it almost always inevitably turns into some kind of discussion of the substance. So just avoid it, right? But these emails and these texts, these group texts and group emails, even if you don't have a quorum, they could turn into a violation to the extent that, let's say two of your board members have a text exchange, and then one of them calls another board member and says, hey, by the way, I was texting with Chairman Johnson, and we thought this about Drain 99. Well, there you go. You have three people discussing Drain 99. So it just gets really dangerous. It just does. Oh, here's a good example. So a county commission administrator sent an email to a full commission as a 2017 opinion and said, hey, look, the chair and vice chair made this decision. It was a human resources issue. I can't remember if it was a firing or hiring or something like that, but I think it was a hiring decision. We made this decision. Let me know before 5 p.m. today if you disagree, if you have an issue with that decision. And so there weren't any further emails exchanged, but the Attorney General concluded that, okay, and this is the administrator that sent it, right? It wasn't the chair, it wasn't the vice chair. It was the administrator sent it to the full commission and said, this happened. This decision occurred by the chair and the vice chair. If I remember right now, I think it was a decision. Here's the list of finalists for this position, I think is what it was. So I think they had pared down the list of potential candidates. We've cut it down to 3. If you have any questions or issues with that, let me know. And the Attorney General concluded that, all right, what that email constituted a meeting because the lack of response was a tacit vote to approve your decision. And so when you're asking for some type of response, when the administrator was asking for some kind of response, or even just saying, if you don't respond, we'll assume this is okay. That's a meeting, the Attorney General concluded. So you can see how tricky it gets when you're talking about emails. Now this gets a little bit tricky because even I myself will send out informational emails from time to time, and I'll say, for me, it's most common with tile projects, for example. A lot of you get these tile permit applications. Look, we only have 3 days to decide if an application is final or complete, and we only have 30 days to make a decision on them. And so we have to get the information out. And so let's say in Trail County, Jessica gets an application. She forwards it to the engineer and to me, Nate, and to me. Hey, take a look at this. I'll look at it, make sure, touch base with the engineer. Does this discharge into a natural? Does it go into a legal, that kind of thing. Get that figured out. Draft proposed minutes, including proposed conditions, because again, we only have 30 days to approve these things. Otherwise, they're automatically approved. So I'll put together draft minutes. I'll put together a draft notice of decision, the draft affidavit. I get everything drafted. This is all within, a few minutes of getting the email from Jessica. And I put together the minutes with a project description and with permissible conditions. And I email it out to the full board. And I say, look, board, FYI, at our meeting next Tuesday, we're going to be discussing this permit application. Nate and I reviewed it. Here's the project description. Here are permissible conditions. And, those get a little tricky in that you don't want anybody responding. You've got a quorum on there. And so what is it? Isn't that a violation? Well, the Attorney General has concluded that, and I've got this sort of lengthy discussion here from an opinion, gosh, what year was that? 2007, it goes back, where the Attorney General concluded that, look, if you're talking about staffers, that's not to say that every email is a meeting, okay? If you're providing information to your board members to prepare them for the next meeting, just to notify them, not to solicit discussion, not to solicit decision-making, but to provide them information, that's not an open meeting violation. And so, I liken it to sending out board packets. So before email, right, you might, the administrators at cities, for large cities, for example, would send out a meeting packet to their commission members by mail. Okay, how is this different? Well, it's different in that folks can reply to emails, and that can get a little dangerous. And isn't that collecting information for a meeting? Well, the Attorney General said that if you're just providing information, just for their information in advance of a meeting to prepare them for a meeting, that's probably okay if it's ministerial. If you're asking them to make a decision, or if you're saying, hey, look, we have some real issues to discuss regarding Drain 99 next meeting, and I need to talk to some of you, or, somebody give me a call. One of the board members would like to give me a call. We can go do a site visit, that kind of thing. That gets dangerous. Even this is a little dangerous. And so what the Attorney General concluded is, hey, look, where do I have it? Oh, down here, right here. When using an email as a means to provide information to the governing body, to your board, include safeguards to make sure that you don't violate the law, right? By soliciting responses, by encouraging quorum discussions. So what I do on my emails is, first of all, I send them blind carbon copy, right? So I'll send them so that managers can't reply. So I'll send it to myself, and then I go down to the BCC, and then I have the other members, the full board, and the secretary, treasurer, and the engineer probably, and that way they can't reply. So that's one thing. And then at the top of those emails, I have this little caveat: hey, please don't reply to this email to ensure that we comply with open meetings requirements. And then I'll say, hey, again, we have this tile application we're going to be talking about next meeting. Here's what I concluded on my review. We'll talk more at the next meeting. So that's kind of ministerial, right? And we've got to act quickly. And they need the information. If we mailed all that out, I'll tell you what, my secretary and my assistant would be very upset if she had to mail out every tile application to every board. So email makes life easier in many ways, but it makes it more complicated from an open meetings perspective. So Secretary Treasurers, I would encourage you, if you have a meeting packet you're sending out, or let's say you get a letter from some angry landowner and you want to provide it to the board, I think that's okay based on the Attorney General opinion. Maybe life will change. Maybe the Attorney General will conclude differently here at some point. But for now, I think it's okay to send it out. But I would encourage you, when you send something out to your full board by email, do it by BCC, and make sure you include that little caveat. Hey, don't reply to this. But again, doing it by BCC ensures that they can't reply to the full board. They could only reply to you. But that's one way to ensure that they comply, right? That they don't violate the open meetings laws by accidentally hitting a reply all and saying, "Oh, thanks, Jessica, for sending that. I know landowner A is very upset, and I'm going to give him a call." You know, if you accidentally hit reply all, then that becomes a discussion, right? So it's an issue. Emails, texts, those kind of things. I, for a long time, a lot of folks have my cell number. My policy has sort of been, look, obviously I don't engage in text discussions with quorums. More recently, our malpractice insurer has now suggested that, and this only recently happened, has only recently suggested that, look, you probably shouldn't even text with anybody moving forward. And so, this is evolving, right? All these electronic meetings, the definition of a meeting is evolving, and it creates risk for all of us. So just be very careful. All right, committees. This gets a little bit tricky. So a governing body, obviously, so if you have a quorum of a governing body, that's a meeting, very clearly. But this happens all the time. There are committees created, and a committee is subject to the same open meeting requirements. Now, clearly, let's say your board, you have 5 members, and let's say you're gonna have a hiring committee. All right, our secretary is retiring. We need a hiring committee to examine applications for the next one, blah, blah, blah. At your meeting, you create a committee comprised of, let's say, 2 of your members and your attorney or something. And you very clearly do that by motion. That committee is subject to the same requirements. You've got to create an agenda, provide notification, you've got to create minutes. So every time you do that, every time you create a committee, that committee is subject to open meetings requirements. So just understand that very clearly. Same exact posting requirements, same agenda requirements, same meeting requirements or minutes requirements. So hopefully you all knew that already. But what happens more frequently is that a committee is sort of created by virtue of your discussion without any formal delegation of authority or anything like that. So here's the definition of a committee. Let's see. When a governing body delegates authority to 2 or more people to perform any function on its behalf, that's a committee. Okay. So do you have to do that by motion? Do you have to create a committee by motion? The Attorney General has concluded on many, many, many occasions, no, you do not. So let's say that, what they said is you do not need to make a formal motion to create a committee. If the governing body consents to delegation of this authority to a group of people to perform a function, you've created a committee. So let's say you're at a meeting and 5 members and oh, we have this drainage complaint come in. What should we do about it? Well, We can't have a whole quorum go out there. That's a special meeting. That's a hassle. Then our secretary treasurer has to show up and do minutes, and we have to post it, blah, blah, blah. Let's have Tom and Ed. Why don't you two go take a look? All right. And the minutes, maybe the minutes don't even reflect it. Or maybe the minutes say, the board reviewed a new drainage complaint. Managers Johnson and Smith are going to conduct a site visit. That's probably a committee creation, right? That enough right there is probably considered a committee, because even if you don't mention it in your minutes, even let's say at your meeting, you say what I just described. And one of your project opponents happens to hear that and perks up and looks for a meeting notice, doesn't see one. And then at the next meeting, the board says, well, managers Smith and Johnson conducted a site visit and X, Y, and Z happened and blah, blah, blah. Okay, well, the board didn't authorize Smith and Johnson to go conduct the site visit. They didn't specifically delegate authority to do it, but just the fact that everybody recognizes they're going to be doing it on the board's behalf is enough, is what the Attorney General has concluded on many occasions. So, or let's say it's Manager Johnson and Secretary Treasurer Peterson are going to, are going to show up at the next budget hearing or something, the county commission's next budget hearing. Okay, they didn't delegate any authority to them, but you've indicated that they're basically going to be acting on your behalf. Maybe you didn't tell them to go, maybe you didn't give them specific authority to show up at the hearing and tell the county commission, well, here's how we're going to do this, but you have recognized that they're going to be there conducting public business on your behalf. So that in and of itself is probably delegation of authority and probably creates a committee and probably invites open meeting requirements. So you've got to create an agenda now for Manager Johnson and Secretary Treasurer Peterson to show up at that county commission meeting. You got to create an agenda. You got to file it with the county auditor. You got to post it at your meeting room. You got to take the agenda to the county commission meeting. You have to post it there, and then you have to create minutes. So the committee thing, all sorts of violations. I see a lot of attorney general opinions on that. Just be very careful to say about saying, well, Manager Johnson and the engineer are going to conduct it. Be very careful about that, because it's probably creation of a committee. Again, they're subject to the same requirements. Here's another situation that I see frequently, these tours. And a couple types of situations. Bus tours, I'll get into that in a second. So on these drain tours, a lot of you probably conduct them, or whatever entity you're with. Maybe you're going to do a facility tour. And maybe you think that creating an agenda that says on Thursday, June 19th, and you have a single item on there, it says conduct drain tour starting at 10:30 a.m. Well, that's really not sufficient. And the reason I know this, Mary Kay Kelsch used to handle open meetings and open records issues for the Attorney General's office. I think somebody else is handling that now, but I remember talking to Mary Kay about this years ago to ask her, look, all right, they do these tours. What's the best way to comply with open meetings requirements for these? And she was great. And we talked through a lot of possibilities. And basically what I ended up doing is creating something like this. All right, so what are the facilities? We're going to do these. We're going to tour these different drains. The special meeting starts at 10:30. We're going to meet at the courthouse. The board's going to meet. I don't go on these things, but the board's going to meet at the courthouse. They're going to leave the courthouse. This was for Sargent County this year. I'm just using this as an example. And they're going to leave for the drain tour. And they're going to get to drain number 8 at 10:45 a.m. Okay, you don't know exactly, right? But you can start late, but you can't start early. So let's say the Sargent County Water Board leaves the courthouse, gets there at 10:42. They better sit there and wait till 10:45 to start discussing anything. Okay, you can start late, can't start early. But this is what I kind of worked through with Mary Kay those years ago, is try to identify all the facilities they're going to tour and try to determine what time they're going to be there. And here's what also I have at the bottom of the agenda. So you cannot and I'll get to the bus tour example in a second, and that'll give you more explanation, but you can't have all the water board members in one car. They all ride in a Suburban, right? And everybody else has to follow. And then you get out at the next facility and you start talking. That's a violation, because you know that a quorum of the board in one vehicle, and members of the public, or let's say the newspaper wants to listen in, they have to follow in their own cars. You know darn well the board members are talking about public business in the Suburban, right? And so what I put right at the bottom is no more than 2 members are going to be in a single vehicle at any given time. And the idea there is we don't want to break the quorum requirement, and we're going to ensure that members of the public have access to all the discussions. So they're only going to have quorum type discussions on site at any particular facility. So like I say, this is something, Mary Kay was great. She helped me through this years ago. This is what I use. Hopefully you'll do the same thing next time one of your entities has a tour. So this bus tour, there was an Attorney General opinion some years ago. It was Fargo Southside Flood Control Project. The city of Fargo was conducting a tour of this proposed project. They had a bus ready to go, but there was limited availability, limited seats in the bus. There weren't enough seats for all members of the media who showed up and for members of the public who showed up. And basically the Attorney General concluded that, well, look, you can't preclude or exclude members of the media or members of the public who want to go on this tour with you to discuss, because we know there's going to be discussion of public business during the tour. You can't preclude them just because there's not enough room on the bus. And so what I ended up doing, and so basically the Attorney General goes on to state in that opinion that, look, if you know that you're going to be outside of your normal meeting room, you have to create and provide reasonable accommodations for a reasonable amount of media or members of the public who might show up. And so if you know that there's going to be, let's say you rent a van or something, you've got 5 members on your board, you have your engineer, you better make sure that there's at least twice as many seats in there, for example. You can't just rent a van that is going to house the members of the board and the other folks who are going to be with, you and the engineer. You can't do that. So there was another bus tour that I happened to work for the FM diversion type on that FM diversion project. There was a tour several years ago, but that they were organizing. And I just knew it was a headache because I knew about this Attorney General opinion, did the same thing, called Mary Kay, and basically and talked through it with her, and she was great, very gracious with her time. And what we ended up concluding is, and we talked through it for a long time, and what we ended up concluding is, all right, what we're going to have to do is we're going to have to rent 2 buses. We're going to have to cut, the public entity piece in half. Half the folks are going to have to ride in one bus, half in the other one. And if members of media want to want to be there, we'll have to let them be there. And we're going to have to. So what we tried to do is we tried to touch base with the TV and stations and the forum and the news outlets to find out, hey, you don't have to tell us, but we'd like to know head count. Can you let us know if you might be there? So we did our best to anticipate how much the media was going to be in attendance, and we tried to anticipate how many members of the public might be there. And so we tried to create reasonable accommodations for the folks that we thought could be in attendance. And so, like I say, the Attorney General's office, they're very busy, and I haven't asked them this kind of thing in quite a while, just because I haven't had the situation arise. But if you have questions about it, talk to the Attorney General's office. They've been great over the years in trying to help you avoid these pitfalls on these sort of weird situations, right? These unique situations outside of your meeting rooms. And so basically, in the end, you've got to anticipate situations arising if you're outside of your normal meeting room situation, and make sure that you have enough accommodations for members of the public who want to be there. All right. So Stacy had asked earlier, sorry it took me so long to get here, Stacy. So what about the winter convention? What about summer meetings. So there are open meetings exemptions. There's a social gathering exemption. So let's say your board has a holiday party. There's a social gathering exemption. So you can have a holiday party without noticing it as a public meeting. Just, you cannot discuss public business at the meeting. And I know that's always the tendency. And I can be a pain to folks, to boards in those situations. I always say, look, if you guys are all going to get together for dinner, make sure you don't talk about business. It's, get together, have a good time, have a drink together, but do not talk about, oh man, that was a pretty contentious meeting last week, huh? Don't do that. So there's an exemption for that. Association meetings, be our winter convention, summer meeting, that kind of thing. There's an exemption for that. And then there are training seminars, this kind of thing. If your full board attended to listen today, that's not a meeting. So there are some exemptions. So again, I'll zip through this again. Public right to access. One thing I will note, this really troubles people often. Somebody shows up at one of your meetings and they're recording your meeting. That can be a little unsettling, right? Well, the statute specifically says they have the right to record your meeting or even broadcast it live on Facebook Live or something. I've heard of that happening too. It's unnerving, but they have the right to do it unless they're, impeding on your meeting. They can't disrupt your meeting by walking in the middle saying, stop, wait, we need to set this up, etc. They can't do that, but they can record it and they can televise it and they can play it live on social media and things like that. Like I say, it's unnerving. I kind of wish the legislature would address that, but they have a right to do it. And they don't have to tell you their name or anything like that either. And that can be a little unsettling as well, but they have the right to do it. Virtual meetings. So a couple things. I'm rambling on here and we're almost to the end here. So I apologize. I'll try to run through some of this quickly. So for virtual meetings, if all you're doing is meeting virtually, then you have to provide access to the public. When you create your agenda, you've got to have a link to your Teams meeting or whatever it is. That has to be part of your agenda. Access to meetings means, again, if you're doing a bus tour, you have to have enough room for folks who you could reasonably anticipate might be there. Teams meeting, you got to have the link on your agenda. You got to make it accessible. So, and like I say, by electronic meetings, the location of the meeting is the electronic address. Well, let's say you're doing your normal meeting. I do this with all my clients now. Ever since COVID, I participate virtually. It makes life easier for me. I've got 3 meetings a day. And so I pop in and out of this meeting and go to that meeting. And so do you have to allow public participation by Teams for that? Well, this on site, let's say in Cass County, Melissa's has the conference room is open. The board is meeting there. Most of them, some of them might be on Teams. Do you have to allow access by Teams? Well, the statutes have been modified in recent years. Basically, what we know is if you're only meeting by Teams and there is no public access in person, then you have to allow people to participate by Teams. But let's say you have your normal meeting and you just happen to have Fredricks is showing up by Teams. Do you have to allow other members of the public to participate by Teams? Doesn't seem like it based on the Attorney General opinions before, as long as you had a public right to the conference room where the meeting is occurring and you have a computer screen or video conference phone or something like that, or a conference phone on the site, you don't have to. I always err on the side of caution though. Look, if somebody wants to participate by Teams, I'm setting it up by Teams anyway. Give them the link. Let's invite access, right? As opposed to you get into a situation where the Attorney General might later conclude that, well, you knew that some folks would want to participate by Teams. You should have given them the Teams link. I always err on the side of caution on that. So one other thing I wanted to note is that you have to provide right to access, right? People have to have right to access, but by statute, they do not have a right to speak at your meeting. So just because, Angry Farmer A because you're discussing something that he may not agree with, he has a right to be sitting there in the conference room for sure. By statute, he has that right, but he does not have a right to, up until I'll get to this resolution here in a second, but by statute, he does not have a right to speak. So, public right to access means they can be there, they can witness the meeting, they can listen to everything you discuss, but prior to now, this last session, you did not have to offer them the right to speak. Okay, but this last session, there was this SB 2180, and it's kind of an interesting story about how we got hooked in, but water resource districts ended up getting included late in this bill. Now we have to have a public comment period, and I've got a resolution for this. I sent that out to my email list. If you didn't get it and you want a copy, let me know. I'll send it to you. But starting in August, you have to have a public comment period on your agendas. And the legislature was very specific in terms of how you could limit it. You don't have to give them unlimited amount of time to speak, et cetera. And you can require them to provide their name and the topic they want to discuss in advance. I've got a resolution that addresses this and lays out a policy for this. And so moving forward, you're going to have a public comment period on your agenda. So if you have a question about this, or if you haven't done this yet, I would advise you to approve a policy for it. And if you want to copy this resolution, let me know. I'll shoot it to you in Word and you can modify it as you see fit, but it contains everything the legislature allows us to address. And so anyway, moving forward, you will have to provide public right to speak, but generally speaking, you don't. Executive sessions, I'm going to run through some of this very quickly. I'm running out of time, so I apologize. Executive sessions, basically the point I was making here is avoiding discomfort is not a legitimate reason for an executive session, basically. So you can have an executive session for attorney consultation if you have ongoing litigation or a reasonably predictable litigation or something like that. But you can't use an executive session just to avoid discomfort, right? And let's say you want to fire somebody or something like that. You can't go into executive session just because it's uncomfortable talking about it. Because let's say your board has an engineer not getting the job done, or an attorney is not getting the job done. You can't go into an executive session to discuss firing them just because it's uncomfortable, and so you have to have very specific rationale for conducting an executive session. Just having your attorney present is not rationale enough. So let's say you have an ongoing lawsuit. You can't go into an executive session and just have your attorney give you well, here's what's happening. Not much has happened and blah, blah, blah. Here's an update. That's not enough. The Attorney General has concluded on many occasions that's not enough. You have to be using the executive session for actual consultation with your attorney to get advice, to talk through issues that if you were in public, it would put you in a disadvantage in litigation or in negotiations. So you have very limited focus in terms of what your executive session can include. And you can't include folks who aren't maybe involved in the litigation, who aren't on the board, things like that. You got to be very careful about who you can include in an executive session as well. Beyond that, you have to be, I'm going to run through some things. You have to be very specific in terms of what you include on your agenda. Just saying, first of all, you have to have the executive session on your agenda. You can't just decide during a meeting, well, let's go into executive session. You can't do that. You have to have it on your agenda, and you have to be very specific about what you have on your agenda. So if you have any questions about that, let me know, but you have to list the statute, and you have to, if you have a case, you have to have the case. You have to list that on your agenda. And then the Attorney General has a really nice script that you have to read, because you have to record your executive sessions. And what I do is I take that script and I modify it, but you have to conduct a reading of the script before you go into executive session, because you have to identify the statutes that justify the executive session. So there's a process. I guess what I would say is just be careful about how you do these things, and make sure that you confer with your attorney while you're preparing your meeting agenda, if you think there might be cause for an executive session. So I'll just run through a couple more things very quickly. Here's the process for executive session. So agendas and meeting minutes. You don't have to have everything on your agenda that you're going to discuss, but you have to include everything that you know you're going to discuss. So at the time, this is from a specific 2010 Attorney General opinion. At the time that you create your agenda, if this is all you put on it, old business and new business, and you know that you're going to be discussing Drain 99 and that complaint, you have to list that on the agenda. Okay. And if you don't, that's a violation. That's an open meeting violation. You know you're going to be discussing it. But if you're at the meeting and you have an agenda with 6 items on it, and somebody at the end of the meeting says, this is at regular meetings only, at the end of the meeting says, oh, there is one more thing I wanted to bring up. That's okay. As long as you didn't know about it at the time that you created the agenda, it's okay to discuss other items. You can vary from the agenda at the meeting as long as you are only discussing things that you didn't reasonably anticipate at the time you created the agenda. So I kind of ran through that. Hopefully that's clear. Posting your meetings, you have to post them at your office. You have to have your agenda posted at your office, file it with the county auditor, post it on your website. You have to file it with or provide it to anybody who's requested notices of your meetings. And then this isn't required for regular meetings, but it is for special meetings. You have to provide a copy of the agenda to the newspaper, not to publish, but just for their information. So I always say, look, get the newspaper on your email list, give them the agenda for every meeting. Okay. And so that's what's required for an agenda. Special meetings, you can only discuss the items that are on the agenda. You can't have an other business topic on your special meeting agenda. You can only discuss what you have on your special meeting agenda. Every year at your December meeting, you should approve a motion to set the next year's meetings, because that's the schedule that you're going to file with the county auditor's office and post on your website. Now, if you say we're going to meet on every second Tuesday at 9:00 next year, okay. If next year during harvest you decide, well, we're going to switch that 9 a.m. to 8 a.m. For next month's meeting, that's a special meeting because it varies from what you file with the county auditor's office. So recognize that, understand that that's a special meeting, and you can't vary from your agenda at that meeting. All right. One more thing I wanted, again, I'm over the time here, so I apologize. I would just want to talk about minutes real briefly. There's a the statute is very specific about what you have to include. Now, what does it say? Names in your meeting minutes, who attended, blah, 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 what you discussed, list of topics you discussed, list the motions that are made, every vote taken. And roll call votes are required for non-procedural. People always say, well, if we weren't spending money, we didn't have to do a roll call vote. You hear that all the time. That's not true. That's not true. Every procedural vote requires a roll call vote. So it doesn't matter if you're spending money or not. If it's a non-procedural vote, it requires a roll call vote. What's non-procedural? I mean, how many times at your meetings are you having motions to table and things like that? Probably not at all. So pretty much every motion you make should be a roll call vote. So FYI, that seems to upset folks. But minutes, it's a delicate balance because, some secretaries do a verbatim account of everything that was discussed. It's almost like reading a script of what happened. Other secretaries include just incredibly vanilla language that says they discussed Drain 9. Next item, and so is that enough? I don't think it's enough. So it kind of depends. And you are subject, as our water resource districts, you are subject to arbitrary and capricious standard on appeal. So the way I approach meeting minutes is, what do you need in the record? If somebody challenges your decision, what do we need in the record for our opinion to survive appeal to district court? And so it's kind of a delicate balance. So sometimes you want a lot of detail because you need to create a record. My tile minutes, for example, tile permits, oddly, I've had like 9 of them appealed, right, to district court. We've won on every single one of them because we have pretty detailed minutes. Some items you don't want as much detail. So, maybe you're at the beginning, you're starting to talk about a new drain, a legal assessment drain project. And sometimes I see minutes that say, landowner Johnson arrived at the meeting, he said that the chairman is doing this for his own benefit and only to benefit his own things like that. Some of that stuff you don't want to go into verbatim, but you want to have enough in there to justify your decision making. So it's kind of a delicate balance. And I'm not telling you to hide things. I'm not telling you to lie. Obviously, you have to be very honest about what occurs during your meetings, but you have to be smart about what you include and what you don't include. Again, sometimes some secretaries want to include a verbatim account of everything that was discussed. I don't recommend that. On the other hand, you got to have something more than just they discussed drain 9. Next item, motion to blah, blah, blah. Probably you need more than that if somebody appeals your decision, you need to protect yourself on appeal. And so it's a delicate balance. A lot of folks will send me their draft minutes after every meeting, which I appreciate because I have a better sense probably at this point for what issue could be appealed. And I like to help out with the minutes on those discussions and make sure that the minutes include what we need if something were to be appealed. So I ran through a lot here, didn't cover everything I wanted to cover, so I apologize for that. Any questions before Danny wraps us up?
Anybody have any questions? Sean, do you want to talk about posting minutes? You have that on the bulletin list.
Yeah. Thanks, Danny. So I do have that.
It'd be good to cover that. Okay,
good. Yeah, I'll do that. So in the 2023 session, there was a bill debated 6116.104 that requires water resource districts to prepare your draft minutes and post them on your website or your county's website, whatever it is, within 10 days of your meeting date. When it was debated, it was originally 3 days. And Danny did a nice job. My example was, okay, so you have a meeting on Thursday and it's Easter weekend. So your secretary is going to be in, so they extended it to 10 days, fortunately. But, when I was just talking about creating your record on appeal, that's kind of what this gets to the heart of that. People want the ability to see your draft minutes so they can decide if they're going to appeal your decisions. Okay. And so you have to post your meeting minutes, your draft meeting minutes within 10 days of your meeting. And what I always recommend that people do is at the top of those minutes say, these are draft and are subject to amendment when approved by the board. But you have to have those posted within 10 days on your website, or if you don't have a website, then on your county website. Yeah. Thanks for pointing that out, Danny.
Any other questions that anybody has?
Sean, I've got a quick question for you.
Sure.
So say you send out your agenda and then something else comes in afterwards, are you supposed to send out another agenda right away with that? Or is it okay to just add it at the beginning of the meeting, or is that really not what you're supposed to do?
So the Attorney General opinions say that you had to know about you can depart from the agenda if it's something that you didn't know about at the time you prepared and posted the agenda, right? So Melissa, what she does is she'll post, correct me if I'm wrong, Melissa, I think you usually post like a couple days in advance or a day in advance, or, so the day before, right? So let's say Melissa posts the agenda at 2:00 on Monday and then we're meeting on Tuesday morning. If an agenda item comes in at 4:30 on Monday afternoon, or something else comes in, you're just fine adding it to the agenda the next day. Based on the Attorney General opinions I've seen, the Attorney General is not going to whack you for adding something that came in right at the end of the day, the prior day. So I think you're just fine adding it as modifying the agenda the next day, as long as it's a regular meeting, or adding it to other business.
Okay,
yeah, good question.
If it came in say I posted the agenda a few days in advance and it came in still a couple days in advance, I should probably send out a new version.
I think in that case, you probably should. Yeah.
Okay. Sounds good. Yeah. Thanks.
I don't mean to create work for you.
I have a question on agendas as well. So how far in advance should we be notifying people of meetings, like the agenda itself?
That's a great question, Sarah. So the Attorney General has concluded that and stated in many opinions that you have to notify the public at the same time you notify your board. So, what does that mean? So when you send out an agenda, if you know on Monday that the next Tuesday you're going to hold a quick special meeting, you can't just notify the board members. So you're supposed to create an agenda right away, basically, essentially, is what the Attorney General has concluded and said that the same time the board members find out is when the public should find out. And so you're supposed to create an agenda. Essentially, you're supposed to create it immediately. But let's say you don't tell the board members until Wednesday. Well, that's fine then, as long as you create the agenda and post it and file it, etc., on Wednesday, the same time you notify the board members, then you're in the clear. But so the Attorney General has basically said the same time you tell the board members is when the public should know. So, just be careful. Let's be careful about calling the board members saying we're holding a special meeting next Monday, and then you don't post the agenda until Friday. You could get into trouble in that instance. That's a great question. There's no specific hours. The statute doesn't say 24 hours, et cetera, et cetera. It's just the same time that the board knows.
Okay, how far ahead in advance of the meeting, though, do you have to post it?
It's a reasonableness, So, I mean, if you know there's going to be a special meeting on Wednesday, if you know it on Monday, you can't wait till Tuesday night at 7:00. It's I can't give you a black and white answer because there is no black and white answer, but basically the Attorney General is going to say it's got to be a reasonable amount of time, and you have to provide it at the same time you provide it to the board members. So I can't give you a definitive answer. It just depends on the circumstances.
Okay, so if you customarily post your agenda on Friday for a Tuesday meeting, can you just stick to that schedule then? I mean, is that enough time in advance for people? Because, as you keep having things come in, especially Mondays before meetings. So
and again, that's one of those reasonableness things. I think Friday in advance of a Tuesday is very reasonable. But let's say over the weekend you get an email from FEMA saying, we're not going to reimburse you X, whatever. And on Monday morning when you get to the office, oh, great, we got to talk about this. It'd be wise to go ahead and amend that agenda, in advance of the meeting if you know about it.
Okay, I have a question in regards to consideration of the bills and for them approving them to be paid.
Mm-hmm.
I know it's public. People should be able to know what we're spending money on. Is there how detailed does it have to be? Right now it's very detailed, and I'm wondering, can that get you into trouble by doing?
Yeah, it's a very good question. So what Melissa does, for example, is she'll include copies of all the invoices that the board's going to consider on the meeting packet. If anybody's interested in knowing, they can ask for a copy of the packet. And then in the minutes, the motion, Melissa, correct me if I'm wrong, I think the verbiage you use is Manager Weston moved to approve bills as presented. I think that's how, that's fine as long as somebody who wants to know what the bills look like can get a copy of them. That's a good question, Lori. I don't think you need to go into the detail in the actual minutes. Bill from, XYZ Engineering in the amount of X. As long as you have copies of the bills and anybody who wants to know what they were, they're open records, so you can. But I don't think you need to go into that detail. That's a good question, Lori.
No, that's good, because I kind of always bothered me a little bit that they went to that detail, and I was just following suit. And
the tough piece with that is, let's say you try to do that and you make an error, right? I do all the time. Let's say you have 15 bills and you're trying to type them all in and you make an error. That creates a problem, a headache, because then a year later, the auditor's looking at it and, this doesn't match up, and it could create problems for yourself. And, in my mind, why create difficulty for yourself?
you know, in the past from, you know, Carrie, she would even put in people's names and what they earned. So isn't that an HR violation by letting other people know what a specific person makes?
Well, that's open information,
That's
unfortunately.
still open?
It
Okay.
is, it
I
is
just wanted to
open.
make
So
sure,
somebody,
you know.
yeah, I know, but it feels, it's a little cringy, right? Because you're telling the world what somebody's making. It's open information. If somebody wants to find out, they have a right to find out. But I guess I sort of side with you that I don't love posting all the bills and the specific, you know, and again, not because I think it's a bad idea for the public to know, but just because I think it creates situations where you might make a mistake inadvertently. And if you're having, you know, your annual audit done, oh man, the minutes say this, but the bill
Right.
invoice says that, and the check was different. And, you know, so you could create problems for yourself unnecessarily.
And would I put a disclaimer in there that, like in the minutes, even copies available upon demand, or?
Yeah, sure. Yeah, you absolutely can do that. Absolutely. That's not a bad idea at all.
Okay.
To make it clear to the public that, look, we're not trying to hide anything. If you want to see the invoices, I'll give them to you.
Right.
Yeah.
Okay.
One thing, if you are gonna write them that way, that I would suggest is the auditors have asked us in the past, if we're not gonna list our bills in the minutes, to have a list that the chair or some manager who is there like signs off on, so they
Oh, yeah.
know what was actually approved. So I might suggest that if you weren't gonna list them in the.
Yeah, I was going to, because I've done that in the past where the list has been too long to really fit to one page of the agenda, or it would just leave the agenda a little bit onto a second page. Well, then I'll just say see attached expenses, and then everybody gets a copy of the list with the detail.
Yeah, Melissa makes a really good point about what the auditor wants to see. And I think, you know, Melissa does a nice job with her minutes. So if you're ever curious about how she does it, go to the, you know, Southeast Cass Water Resource District website and look at her copy of her minutes.
Okay, and then with the posting the agenda with the, is it with the state auditor?
County auditor.
A county auditor. Oh, it's on the county website, is our website. Does that suffice for that, or do I have to send it to somewhere?
Yeah, that's sufficient. That's sufficient. I guess what I would, as a regular practice, anytime you have a meeting agenda and you circulate it by email or whatever, just make sure the auditor's office is listed on there, obviously, and then
Okay.
post it on your website or the county's website. It's probably a good idea to have them on both, or if they house your website, that's probably sufficient, you know, that kind of thing. But yeah, filing with the county auditor, what does that mean, right? It just means getting it to the county auditor's office. And if you have it posted on their website or yours, it says either file it with them or post it on your website. Do both.
Oh,
Do both.
okay.
Yeah.
I thought you said both. So
do both. Like I said, anybody wants a copy of this, let me know. I'd be very happy to send it to you. You know, or if you want some samples, or if you want that resolution, the SB 2180 resolution or drain tour agenda, anything like that, let me know. I'd be happy to share it with you. So thanks to Danny and Jack. I don't know if Jack's on, but they did a lot of nice work on 2180 and all these other open meetings issues and all the other water resource district issues. So thanks to them.
Well, thank you so much, Sean, for your time today. This was really helpful. I did put in the chat, if you can see that. I did put a short survey together asking for some feedback. This is the first of what I hope is a series of trainings we can provide for you all. So if you guys have ideas on different topics you have questions about, or speakers you think would be good to hear from, please share that with us so we can get those scheduled here in the future. And like Sean said, if you want copies of anything, you can let him know. If you can let me know, and I get that over to him as well. And we'll make sure that you have the resources. And like I said at the beginning, this was recorded. So when we get the recording finalized, we'll send it out to everybody, and feel free to share that with, if there's other staff that weren't able to make it, or if you have board members that you think would be interested in this information, feel free to share it with them. And with that, thank you all for your time this morning. We'll talk to you later.
Thanks, Danny. Thanks, everybody.
Thanks,
Thanks.
Sean.
You.